Case 12. Vreeland, the plaintiff, versus Ferrer, the defendant. For this case, we find ourselves in the Florida state court system, more specifically within the Supreme Court of the state of Florida. Facts of the case. The facts of the case are not difficult to understand, but the legal analysis is involved, and keeping the parties and their relationships clear is very important. The parties are as follows. Danny Ferrer is the lessor, who leased an airplane from Aerolease of America, Inc. for 1 year. The plane crashed after takeoff from an airport in Lakeland, Florida. The pilot was Donald Pallas, and his passenger, Jose Martinez, both died. John Vreeland, in his capacity as administrator ad litem and personal representative of the estate, filed a wrongful death action against Aerolease as the lessor of the airplane. In a wrongful death case, the victims are represented by an estate, and survivors and representatives sue in that capacity. So let's define these terms. When an estate must be represented and the personal representative is unable to do so, the court shall appoint an administrator ad litem without bond to represent the estate in that proceeding. The personal representative can be an individual or a bank or trust company, subject to certain restrictions. To qualify to serve as a personal representative, an individual must be either a Florida resident or, regardless of residence, a spouse, sibling, parent, child, or other close relative of the decedent. Now let's define vicarious liability. Liability that a supervisory party, such as an employer, bears for the actionable conduct of a subordinate or associate, such as an employee, based on the relationship between the two parties. So what was the issue? Whether the claim against Aerolease could advance under Florida law. More specifically, Vreeland filed a petition with this court seeking review of the 2nd District's decision on the basis that it expressly and directly conflicts with the decision of this court in Orifice, and this court accepted review. The holding. Florida's dangerous instrumentality doctrine applied, and according to the Florida Supreme Court, the 2nd District erroneously affirmed summary final judgment in favor of Aerolease on the basis of federal preemption. In other words, the claim against Aerolease could advance under Florida law, a victory for the plaintiff to proceed with its claim. Let's go into some of the reasoning behind all this. Pursuant to Florida's dangerous instrumentality doctrine, the owner or lessor of an aircraft is vicariously liable for the negligent conduct of a pilot. However, the court granted summary judgment, concluding that 49 U.S. Code 4411(2) preempted Florida law, and because Aerolease was not in actual possession or control of the aircraft at the time of the crash, the company was not responsible under the provisions of the federal statute. Vreeland filed a motion for reconsideration, asserting that the trial court's decision on vicarious liability effectively overruled the 1970 decision of the Florida Supreme Court in Orifice. In Orifice, the court held that an airplane was a dangerous instrumentality and a wrongful death action could properly proceed against the co-owner of an airplane on the basis of vicarious liability. Let's talk about limitation of liability. A lessor, owner, or secured party is liable for personal injury, death, or property loss, or damage on land or water only when a civil aircraft, aircraft engine, or propeller is in the actual possession or control of the lessor, owner, or secured party, and the personal injury, death, or property loss or damage occurs because of 1. The aircraft engine or propeller, or 2. The flight of or an object falling from the aircraft engine or propeller. Florida's dangerous instrumentality doctrine imposes vicarious liability upon owners and lessors of aircraft, even where the aircraft is not within their immediate control or possession at the time of loss. Here, the Supreme Court of Florida determined that to the extent that the doctrine applied to injuries, damages, or deaths that occurred on the surface of the earth, the doctrine conflicted with and is therefore preempted by Section 4411(2). Now the potentially tricky part, because according to the majority, the death of Martinez occurred while he was a passenger in a plane that crashed, not on the ground or earth beneath the plane. The wrongful death action filed by Vreeland was not preempted by Section 4411(2), according to the court.